becomes titled in their joint names. So now let's say we have a 2014 vesting deed which shows that title is vested in John Doe and Mary Smith, husband and wife. But in fact, they started living together in 2011 and they were not legally married in any jurisdiction. John Doe then dies in 2017. John's death certificate says there was no surviving spouse, and Mary Smith confirms that they were never married. Regardless of the inclusion of the words husband and wife on the deed, this is not considered a tenancy by the entirety's property. It does not matter if the deed into the spouses does or doesn't say that they are husband and wife or spouses in order for the ownership to be considered a tenancy by the entirety. The rule of construction is that where property is acquired specifically in the name of a legally married husband and wife or legally married persons, a tenancy by the entireties is created in the absence of express language showing a contrary intent. Of course, if there is a pending transaction, there is doubt as to the marital status of the properties. Some evidence of marriage may be required, and you may require that an affidavit of marital status be recorded. Common law marriage doesn't work for the ownership to be considered a tenancy by the entireties. Some states do recognize common law marriage if a couple has lived together for a certain period of time and held themselves out to be married. The courts in those states may consider factors such as whether the couple has joint financial accounts, if they tell people that they are married, and if they recognize that the other person has the authority to make financial and health care decisions for each other. However, Florida's laws are very clear on common law marriage. Florida Statute Section 741.211 makes common law marriages void in Florida. The statute says that any common law marriage entered into after 1967 is invalid. Therefore, if the parties began a relationship after January 1st, 1968, they cannot be considered to be legally married in Florida without a marriage license, regardless of how long they've been together. They could have lived together and claimed each other as spouses since January 2nd, 1968, but the state of Florida will not recognize that as a valid marriage. Title can be transferred from one spouse to both spouses, and there's no need for anyone else to be involved in that transfer. And tenancy by the entireties extends to same-sex marriages. Same-sex marriage has become legal in Florida since January 6, 2015. For conveyances of tenancy by entireties property, both spouses must join in on the conveyance to a third party. It is not acceptable that the spouses sign separate deeds, as there should only be one deed. If the conveyance is between the spouses, only the spouse conveying the property must execute the deed. So, for example, if title is vested in John Doe and Mary Doe, husband and wife, John can convey to Mary without the joinder of Mary. If the property is owned by one spouse, tenancy by entireties rules are not applicable, whether the property was obtained prior to or subsequent to the date of marriage. However, it may be converted to tenancy by entireties property, but that conversion is not automatic upon marriage and would have to be done via deed. If the property is owned by John Doe alone, John may convey to himself and Mary as tenants by entireties without joinder of Mary required. Or John may convey to Mary, and in accordance with Florida Statute Section 689.11, expressly state his intent to create a tenancy by the entirety's estate. Also note that even if the property remains titled in only one spouse, that property may convert to a marital asset at some point. So keep that in mind, particularly when dealing with a divorce, since the non-titled spouse may claim an equitable interest in or lien on the property. If title is vested in one spouse and the property is homestead property, requirements are imposed on transfers and devises similar to tenancy by entireties property, and spousal joinder is required. But if title is vested in one spouse and the property is non-homestead, then spousal joinder is not required. The deed should contain non-homestead language. Otherwise, this will be brought up and questioned on a subsequent transaction, and it will need to be clarified and taken care of at that time. Now we get to the unpleasant part, death. If title to the property is held as tenants by the entireties, the death of one spouse automatically vests title in the surviving spouse. There is no need to prepare a new deed to evidence that title is vested in the surviving spouse. Probate for the first spouse to die is not necessary when dealing with tenancy by the entirety's property. There will be a requirement to record evidence of death for the deceased spouse. Some acceptable evidence includes a death certificate and/or probate documents. And unless there is evidence to indicate otherwise, the presumption is that the spouses were married to each other without interruption until the death of the first spouse, and that the tenancy by the entireties continued until such time. Nonetheless, a continuous marriage affidavit will likely be required for recording. Keep in mind that when the surviving spouse deeds the property out, they should not just deed out as the surviving spouse of the decedent. There needs to be a statement about that person's marital status at the time of the conveyance. They should not just deed out as a single person unless there is evidence that the spouse has died or they validly divorced. But stating that the person is the unremarried spouse of the decedent is acceptable. But what if one spouse caused the other spouse's death? What happens to inheriting property, including tenancy by the entirety's property? As of April 2nd, 1982, Florida Statute Section 732.802 Sub 1, this statute itself is known as the Slayer Statute. This Sub 1 provided that the survivor who unlawfully and intentionally kills or participates in the death of the decedent is not entitled to any benefits under the decedent's will. The estate of the decedent will pass as if the killer had predeceased the decedent. Section 732.802 Sub 2 specifically provides that the unlawful and intentional killing of one spouse by the other terminates a tenancy by the entirety, and the surviving spouse has no right of survivorship. This statute also applies to joint tenants with right of survivorship and any other form of co-ownership with right of survivorship. A final judgment of conviction of murder in any degree is conclusive for severing the right of survivorship under the statute. In the absence of a conviction of murder in any degree, the severance of the right of survivorship is determined in a court proceeding in which the unlawful and intentional killing need only be proved by the greater weight of the evidence. This is according to Florida Statute Section 732.802 Sub 5. Now, Florida Statute Section 736.1104 has similar provisions concerning a beneficiary of a trust who unlawfully and intentionally kills or participates in the death of the settlor or other person on whose death such beneficiary's interest depends. Here, too, the slayer is not entitled to any interest from that trust, including homestead property. The statute also applies to a beneficiary who is a decedent's surviving spouse. Note that application of the Slayer statute is not just limited to the surviving spouse, but also extends to the decedent's heirs and devisees. Thankfully, I have not been involved in any transactions where any of these sets of circumstances have been present. And right now I'm looking for some wood so I can knock on it. Hopefully, neither have you. What about judgments and liens and tenancy by the entirety's property? Valid judgments against both spouses will attach the property held as tenants by entireties. A judgment against only one spouse does not attach to the property unless the judgment in question is in favor of the United States of America or the Internal Revenue Service for things such as tax liens, restitution liens, federal criminal fines, etc. That's the exception to the rule. The 2002 case, the United States versus Kraft, held that a federal tax lien against one spouse attaches to that spouse's interest in entirety's property. A release of the lien will need to be obtained from the Internal Revenue Service, or else exception would need to be taken in a policy for an enforceable federal tax lien that has been recorded against either spouse, where the property being insured is owned as an estate by the entirety or by the survivor of an estate by the entirety. The protection against single spouse judgment inures to the surviving spouse when not dealing with an exception to the rule scenario. And a federal tax lien against one spouse who owns the entirety's property may survive the death of that spouse and continue as a lien on the property of the survivor. So as you can see, these cannot be ignored, and an actual satisfaction or release would need to be obtained. Now let's talk a little about homestead property in the Florida Constitution. So what is homestead property? Florida homestead property is a natural person's principal residence in the state of Florida of no more than 1/2 acre of contiguous land in a municipality or 160 acres in an unincorporated county. If the property is homestead, the Florida Constitution imposes requirements on transfers and divises, similar to tenancy by entirety's property. Pursuant to Article 10, Section 4 of the Florida Constitution, the owner of the homestead property cannot convey or encumber property without joinder of spouse. If the property is conveyed without spousal joinder, the instrument is generally considered void. A mortgage executed by the owner of homestead property without spousal joinder has been held to be ineffectual as a lien until such time as the spouse joins in on the mortgage or the property loses its homestead status, provided that the mortgage contains covenants of warranty. A deed purporting to convey title to or a mortgage purporting to give a lien on homestead property is invalid under the Florida Constitution unless the married owner's spouse joins in the conveying of title to or mortgaging of the property. They need to sign the deed or the mortgage. For our purposes, these are not effectual, they're not effective, or enforceable as liens or transfers of title and are uninsurable. Transfer restrictions also apply to attempted devises. The homestead is not subject to devise if the owner is survived by a spouse or minor child, except the homestead may be devised to the owner's spouse if there are no minor child or children. But I also want to bring up Florida Statute Section 732.7025. This statute was passed in 2018, and it allows the spouse to waive his or her right to inherit homestead property. The spouse may waive his or her rights as a surviving spouse with respect to the devised restrictions under Section 4C, Article 10 of the state constitution. But a deed is needed, and particular and specific language as prescribed by the statute must be set forth therein. This does not affect the rights of minors, and those minors' rights cannot be waived. And this does not eliminate the need for the spouse to join in on a conveyance or a mortgage of homestead property. The statute explicitly states that the waiver language may not be considered a waiver of the restriction against alienation by mortgage, sale, gift, or deed without joinder of the owner's spouse. So even if the deed with appropriate waiver language exists, you will still need spousal joinder. Many times people do not understand that this waiver is different and has nothing to do with that which is required under the Florida Constitution as the spousal joinder. I know I've been involved in underwriting transactions trying to explain what a waiver under the statute does and does not mean. I even had a transaction with an agent where this was the scenario, and since the spouses were divorcing, no one wanted to cooperate. I was actually subpoenaed because I would not authorize closing the transaction without spousal joinder on the mortgage on homestead property. That deal eventually closed, and of course it closed with spousal joinder. Let's go over a homestead sale example involving separated spouses. In our first scenario, John Doe purchases property as a single man in 2005. John Doe later marries in 2007. John Doe and his spouse are later separated. His spouse moves out, and John has no idea where his spouse is, or so he claims. He has had absolutely no contact with his spouse for over 10 years. Again, or so he claims. John Doe agrees to sell his homestead property and provides a deed to a new owner, supported by an affidavit asserting that he is separated, he owns the property outright, and his spouse's whereabouts are unknown. Is John's deed to a third party without joinder of his spouse valid? What do any of you guys say? Any opinions?
I'm going to go no.
Okay, you're right. John's deed to a third party without joinder of his spouse is not valid. Being separated is not the same as being divorced, and the fact that the property is titled only in his name has no bearing. The property is homestead property. I've also had situations where these same facts were presented to me prior to closing. You get the story, I haven't been in touch with this person, I have no contact, no way of knowing. And then it's amazing how many times they suddenly locate that spouse when told that the transaction can't close without the spousal joinder. Here's a homestead mortgage example. And again, we have separated spouses. In scenario 2, John Doe and Mary Doe married in Iowa in 1987. John and Mary separate in 1995, and in 2000, John moves to Florida and buys a Jacksonville condominium. Mary buys a Palm Beach home in 2015 and now wants to use the home as collateral for a mortgage. The parties submit a witnessed and acknowledged waiver of rights signed by John and Mary, releasing any rights in the other's property and waiving all homestead rights. Mary wants to sign the mortgage on the Palm Beach property without joinder of John based on the waiver agreement. Is the mortgage on Mary's new homestead valid without John joining in on the mortgage? What say you? Anyone?
I say no again.
Yeah, no.
The mortgage on Mary's new homestead without joinder of John is not valid, regardless of the agreement signed between them. This is, again, a scenario where many times people misunderstand what can and cannot be done and what we can and cannot accept. Here's, I think, our last example. So here's a homestead purchase and mortgage example. We have separated and divorcing spouses. In scenario 3, John Doe and Mary Doe married in Florida in 2010. John and Mary separate in 2018 and start divorce proceedings in 2020, which are still ongoing because they cannot agree on absolutely anything. John bought a mobile home in Miami, and Mary is purchasing a home in Broward County, which she says will be her homestead right after the closing. She's obtaining a mortgage, and the lender says that she can sign a loan because she's divorcing and the property is not her homestead yet. Since Mary has been counseled by the lender, she wants to sign the mortgage on the Broward home without joinder of John. Would the mortgage on Mary's new homestead be valid without John joining in on the mortgage? Again, I'm going to ask you guys.
No, because they're still married and not divorced yet.
Okay. The mortgage on Mary's new homestead without joinder of John is not valid, regardless of the fact they are divorcing and regardless of what the lender is or is not willing to accept. Mary has advised that the property will be her homestead once she purchases it, so the mortgage requires spousal joinder. Again, I was involved in a transaction with a similar fact pattern. The parties were arguing as to assets, distributions, properties, children, basically anything and everything they could argue about. When Everyone kept insisting that the spousal joinder was not happening. Despite the fact that I explained to them why it was necessary. Um, I suggested that the wife either enter into a lease of the property until the divorce was finalized and purchase the property then, or that they bifurcate or sever the proceedings so that the divorce portion could actually take place. And then they could settle all of their arguments about assets and all the like separately. So that if that divorce did happen before the purchase of the new homestead, that joinder wouldn't be necessary. Um, After much back and forth, in my case, the wife ended up paying the husband some money for his cooperation, and he then willingly joined in on the mortgage. I would not doubt that they are still fighting it out in divorce court at this time. Now we get to encumbrances. As you know, if both spouses are entitled, both must sign the mortgage. Otherwise, the mortgage would be rendered unenforceable as an encumbrance and result in a possible and potential claim against the policy. A non-homestead affidavit and a waiver of rights or interest in a property are insufficient and do not trump the restriction from alienation found in the Florida Constitution. I've seen claims where somehow, some way, I don't know, someone decided that the parties entitled did not all need to join and sign the mortgage. Sometimes people think that because not everyone entitled is going to be on the note, that they don't need to sign in on, join on the mortgage. It's fine if they're not all on the note, but they must all sign and join in on that mortgage. Without all joining in on the mortgage, you're looking at a claim, and nobody wants that. If only one spouse is entitled but the property is homestead, again, both must sign in on that mortgage and join in on that mortgage. Many times that the actual spouse that's not an actual title to the property is reluctant to sign the mortgage. They think that they're obligating themselves to a lot more than just signing the mortgage. If that happens, you may offer that this blurb or something very similar be added to the mortgage. John Doe, spouse of mortgagor, is joining in the execution of this mortgage solely to comply with the joinder requirements of the Florida Constitution and does not intend to be bound by any of the covenants or warranties contained in this mortgage, nor to be liable for repayment of the notes secured hereby. Of course, in these types of situations, the lender has to approve of that additional language, but that shouldn't be a problem. It's very common, and most of the lenders are used to that. Also note, as we saw with one of our examples, that even if the lender says they will not require spousal joinder, if the property is homestead, we will still require spousal joinder in order to ensure the transaction. I've had a few transactions where a lender said they didn't care about whether the spouse joined in, and I had to explain to them, via our agent about homestead and the spousal joinder requirements. This happens many times when dealing with an out-of-state lender. It doesn't matter if the spouses are separated or are divorcing, or if the non-owner of the homestead property has another homestead. I can't repeat enough that the owner of homestead real property, only when joined by the spouse if married, may alienate that homestead by mortgage, sale, or gift. Now let's go over some examples of invalid devises of homestead. In our first example, John Doe buys property as a single man, then gets married. He dies, survived by a spouse and or a minor child. His will leaves everything to his adult son by a prior marriage. In our second example, John Doe and Mary Doe, husband and wife, convey their homestead property into each of their trusts, which provides that upon death, the trust property is to go to each other for life with a remainder to their 3 adult children. And looking at both of these examples, we need to always consider the constitutional restriction on devise when there's a spouse and or minor child or children. As previously discussed, Article 10, Section 4 of the Florida Constitution provides that if the deceased spouse is survived by a spouse or minor child or children, no devise of homestead property is permitted, and if the deceased spouse is survived by a spouse but no minor child or children, homestead may only be devised to the surviving spouse. So in neither of these examples was the constitutional restriction on devise of homestead taken into account or followed. A homestead does not lose its character by being transferred into a revocable trust. Constitutional limitations on testamentary transfers of homestead property may not be circumvented by placing the homestead property into that revocable trust. To do so would amount to a violation of the constitutional restraint on devise, and the property then passes under the laws of intestacy. Florida Statute Section 732.401 provides that if the homestead property is not devised as authorized by law and the Constitution, homestead descends in the same manner as other intestate property. But if the decedent is survived by a spouse and one or more descendants at the moment of death, title would pass to the surviving spouse for life, with the remainder to the lineal descendants, or to the surviving spouse in fee simple if no lineal descendants. Or, in lieu of a life estate, the surviving spouse may elect to take an undivided one-half interest in the homestead as a tenant in common, with the remaining undivided one-half interest vesting in the decedent's descendants in being at the time of the decedent's death, in accordance and in compliance with the statute. So in our first example, deeds from the surviving spouse and the decedent's lineal descendants and heirs, as determined by proper probate proceedings, would be required. And in the second example, deeds from the surviving spouse, lineal descendants or heirs of the decedent, as determined by proper probate proceedings, and from the trustee would be required. Yes, but wait a minute. In our second example, the end result may be the same as John Doe and Mary Doe wanted per their trust provision, but that still doesn't make it a valid device. And something else to consider is Florida Statute Section 732-7025, which we discussed earlier. By way of reminder, this statute became effective on July 1st, 2018, and was created to provide a legal mechanism for a spouse to waive his or her rights as the surviving spouse in homestead property via a recitation placed in a deed, which also contains the joinder of the waiving spouse. The deed must contain specific operative waiver language, which language must be substantially similar to the following. By executing or joining in this deed, I intend to waive homestead rights that would otherwise prevent my spouse from devising the homestead property described in this deed to someone other than me. When effective, this waiver only operates in the context of the death of the spouse holding the ownership interest in the homestead, whether individually in fee simple, as settlor of a revocable trust, or as a life tenant holding an enhanced life estate. But if there's a minor child, the minor still has his or her rights that cannot be waived. Oh, sorry. And when effective, this waiver still has no effect on the necessity of spousal joinder in any conveyance or mortgage of the homestead property, while both the waiving spouse and the ownership spouse are still alive. Now, what about non-homestead property? If title is taken in one spouse's name, the spouse who owns the property controls the property and can convey or encumber the property without joinder of the spouse when it is non-homestead property. Conveyance documents should always contain a non-homestead clause. But whether or not a property is homestead can be a factual determination. You should check to see if the homestead exemption is being used or if homestead is established elsewhere. Does the driver's license, voter registration, or other documents show a different property as being the homestead? Is there anything of record showing this property as a second home or that homestead is elsewhere? Take the time to Google both spouses, see what information can be obtained. Always ask questions. Don't be afraid to ask questions. Don't be afraid to ask for further documentation. And when in doubt as to whether the property is homestead property, it would probably be wise to ask for spousal joinder. You can also reach out to your favorite steward underwriter to discuss. I remember I was involved in a multi-million-dollar loan transaction where residential property was purchased just 2 months prior, and it was titled in the name of a husband and wife as co-trustees of a revocable trust, which also bore the same date as the vesting deed. The deed did not contain any powers, and the husband was telling our agent that only he needed to sign the mortgage as the trustee. So our agent requested a copy of the trust, reviewed it, and then also sent it to me to discuss. Aside from there being some serious concerns about the wife not signing as a co-trustee, the trust also stated that although they lived in Texas, the subject property was being purchased as their homestead and was always to be considered their homestead until sold. The husband would not budge, and he kept insisting that the property was not homestead and that his wife also did not need to sign the mortgage in any capacity, whether it was individually and as trustee or individually if we got to the point where we were comfortable with the wife not signing as a trustee. The husband kept throwing every excuse at us. He kept pointing to different sections and provisions of the trust as to why the wife did not need to join in on the mortgage. But at this point, I also was not budging on the requirement to have her sign because I really was unwilling to buy an immediate claim. It's not that I wanted to delay or kill the deal. It was that I was trying to look out for the best interest of our agent and the company. The borrower did try to shop the deal around to other title insurers, but I really don't think he was too successful in getting his way because I heard from the agent on the same deal about 5 months later, and it eventually did close with the wife joining in as a co-trustee and also individually. It just, you know, when something doesn't feel right, don't be afraid to question, and that's exactly what happened in this situation. And what about prenuptial or even postnuptial agreements? I'm sure you may have been involved in transactions where one spouse is looking to mortgage or to sell homestead real property without that spousal joinder, and they produce a prenuptial or a postnuptial agreement in support. Sounds pretty good, right? If it's in writing and executed by the parties, we can go with it, right? Well, not so fast. Stewart requires a judicial determination that the agreement, whether a prenuptial agreement or postnuptial agreement, was validly entered into by the parties. We've all heard about cases where spouses are divorcing and one is claiming that the prenuptial or postnuptial agreement signed is not valid or needs to be interpreted differently. At times, people claim that they were misled or forced to sign the agreement. We do not and cannot interpret the validity of the documents. We cannot know what a court will decide about that agreement until the court actually does decide. And then we need to be sure that it is a final unappealable order or judicial determination. And having worked at another major underwriter for many years, I know that this is the same way that other insurers view these types of agreements. So the day has come and the husband and wife are divorced. Tears may have been shed, and some may be experiencing doubts and even regrets. Or the divorce parties and celebrations may be taking place that evening. But we've gotten to the part where likely he, she loves me not. Now, what happens to the tenancy by the entirety's property? Upon divorce, the tenancy by the entirety's form of ownership is destroyed and ceases to exist. Let's say that prior to the divorce, title to the real property was held as John Doe and Mary Doe, husband and wife. Obviously, we're dealing with a property that was held in a tenancy by the entirety situation. Typically, the default position upon the entry of the final judgment of dissolution of marriage is that title is held 50-50 as tenants in common, and that divorce actually destroyed the tenancy by the entirety's form of ownership unless otherwise provided for within the settlement agreement and or the final judgment. The final judgment of divorce can act as a conveyance of the property, but that's not always what happens. It's important to review the documents and the specific language used. We've seen situations where the final judgment of divorce and or the settlement agreement states that it awards the husband or wife the property, but then goes on to provide that the husband or wife must execute a quitclaim deed for that transfer. So the final judgment of divorce in this case does not act as a conveyance without the quitclaim deed. Beware of a foreign final judgment of divorce acting as a conveyance when Florida property rights are at issue. A foreign divorce judgment alone cannot operate directly on the title to lands in another state, as there are jurisdictional limitations. It's similar to like when you're dealing with a foreign probate or guardianship. You see that there are limitations in those scenarios too. And judgments or liens against one spouse may now attach due to the change in ownership from tenancy by the entireties to tenants in common. The final judgment of dissolution of marriage or divorce must be carefully reviewed to see if it acts as a conveyance of the property. A divorce judgment may award real property as lump sum alimony or special equity. The final judgment must specifically grant title to the property to one of the parties unless it provides that the property is to continue to be owned by both. If the final judgment calls for a deed from one spouse to the other, a deed is required unless that judgment says it will act as a conveyance absent a deed. Does the final judgment identify the property? What if it only identifies the property by address? The final judgment must specifically identify the property by legal description or address. If only an address is used, an affidavit from a surveyor connecting that legal description to the property may be required. Or is a deed needed from one spouse to the other? Does the final judgment and or marital settlement agreement provide for what happens if a deed is not executed? Again, the language in the final judgment and marital settlement agreement is key and needs to be reviewed carefully. When in doubt, reach out to your favorite steward underwriter for assistance. Now we get to the property settlement agreement, also known as the marital settlement agreement or MSA. Most people that divorce have some sort of agreement to deal with assets, properties, children, etc. Really, the only times you shouldn't see one is when people are divorcing and they have absolutely nothing, no assets, no properties or children or anything of that sort. So, should you review the marital settlement agreement? Absolutely, yes, it should be reviewed. What if the parties don't want to provide you with a settlement agreement? Well, these agreements are technically public record, even if they're not recorded. So you may have to remind the parties that you are entitled to receive and review same, since you are being asked to close the transaction and ensure title via a steward title policy. So of course, you are not going to do anything with it other than review it for the title insurance purposes, but review it you must, even if it's a redacted copy. We don't care if they strike out their personal, identifying information, but we do need to see what's in that agreement. And even if the divorce judgment or that settlement agreement awards the property to one spouse, it is necessary to review all those documents to ensure that no monetary interest in the property was awarded to the other spouse, which could create an equitable lien. If the divorce judgment or the settlement agreement requires that value be given in exchange for the award of the property, or requires a certain percentage of the proceeds upon the sale of the property to a third party, or refinance of the property be paid to the spouse not entitled, a release must be obtained from the spouse evidencing that they have either received or are receiving any monetary interest they have in the property. The language can also be inserted in a quitclaim deed too, but we'll definitely need to see release language when appropriate and necessary. And of course, there will be instances when neither the divorce judgment nor the property settlement agreement reference a particular property, especially those titled in one spouse's name, or even what happens to it. We see this a lot with the do-it-yourselfer divorces. In these cases, you may want to reach out to a steward underwriter because numerous factors need to be considered and reviewed, such as the original vesting, documents of record, how long ago was that divorce finalized, etc. So, when there's a doubt, reach out to us. Here's a claim scenario. John and Mary held title as husband and wife, then got a divorce. John executed a quitclaim deed to Mary with language that states it was pursuant to a property settlement agreement. Mary later conveyed to a bona fide purchaser for value, otherwise known as a BFP. The settlement agreement was not produced. John's attorney contacted Stewart as he was to receive 50% of the proceeds at the time of sale. This claim illustrates the review of the property settlement agreement is very important. Do not just go by the fact that there is a quitclaim deed of record from the spouse. In this case, the quitclaim deed refers to it being pursuant to a property settlement agreement. So naturally, the terms within that agreement are very important, and without reviewing the agreement, you just can't guess as to its contents. The agreement may have stated that John was required to execute a quitclaim deed and then wait to receive money upon the happening of an event or passage of time. Does that deed contain any type of release language of any monetary obligations that may be set forth in the agreement or the judgment? This is going to be fact sensitive, and you certainly don't want to be involved in a claim that could have been avoided by reviewing that settlement agreement. And aside from the topics we already covered, divorce affects other things that may not be obvious at first blush and that don't always directly affect title to real property. Some of those are as follows. A spouse or attorney in facts authority under a power of attorney is terminated upon filing of an action for dissolution of marriage pursuant to Florida Statute Section 709.2109. What happens with wills after a divorce? Under Florida Statute Section 732.507, any provision of a will executed by a married person that affects the spouse of that person shall become void upon the divorce of that person or upon the dissolution of the marriage. After the dissolution or divorce, the will shall be administered and construed as if the former spouse had died at the time of the dissolution or divorce, unless the will or the dissolution or divorce judgment expressly provides otherwise. IRA beneficiary designation of spouse or void under Florida Statute Section 732.702, and the asset passes as if the decedent's former spouse predeceased the decedent. Revocable trust provisions affecting settlor spouse become void under Florida Statute Section 736.1105, which provides that unless the trust instrument or the judgment for dissolution of marriage or divorce expressly provides otherwise, if a revocable trust is executed by a husband and wife, or by a husband or a wife as a settlor prior to entry of a judgment for dissolution of marriage or divorce of the settlor from the settlor spouse, any provision of the trust that affects the settlor spouse will become void upon entry of the judgment of dissolution of marriage or divorce, and any such trust shall be administered and construed as if the settlor spouse had died at the time of the dissolution of marriage or divorce. 401k provisions are determined under federal law. ERISA provisions will preempt state law or rules where retirement benefits are provided through employer plans or provided under federal programs. And also, Florida Statute Section 732.703 deals with certain assets with beneficiary designations and enumerates the following types of assets or accounts where an ex-spouse's interest is nullified automatically following dissolution of marriage or divorce. A life insurance policy, qualified annuity, or other similar tax-deferred contract held within an employee benefit plan, an employee benefit plan, an individual retirement account described under certain sections of the Internal Revenue Code, including an individual retirement annuity, a payable on death account, a security or other account registered in a transfer on death form, a life insurance policy, annuity, or similar contract that is not held within an employee benefit plan or a tax qualified retirement account. So while the statutes refer to are helpful, it's always recommended that divorced spouses be proactive with their directives and personal property. And now we will discuss certified judgments. Pre-divorce judgments or liens against one spouse will attach to real property upon the final judgment of divorce being recorded, unless the final judgment of divorce is self-executing and acts as an automatic conveyance of the real property or awards the real property to the non-debtor spouse on the basis of support, alimony, special equity, or some other ground that identifies a special interest of the non-debtor spouse in the property and provides that the non-debtor spouse shall obtain sole title and possession of the property. In this case, the judgment or lien will not attach. An example would be John Doe and Jane Doe own real property as husband and wife. Upon divorce, that property is owned 50-50 by each as tenants in common. There's nothing acting as an automatic conveyance to either spouse. So a judgment or a lien against either John or Jane will attach to his or her 50% interest in the property. But if the final judgment of divorce contains the magic words and acts as an automatic conveyance of the property or awards the property to the spouse, there's no attachment of that judgment or lien. Truth be told, it really would be nice and it would make all of our lives easier if more final judgments of dissolution contain the actual automatic conveyance language. And I'm honestly really not sure why it's not done more often, especially when the parties have divorce attorneys. Now, what happens if the parties get divorced and then fall madly in love again and remarry? This happens more often than one might imagine. If the parties remarry, they will have to retitle property since the tenancy by the entireties was destroyed at the entry of the divorce judgment. If not retitled, they will still be tenants in common. This is a common mistake made, and probate of that 50% interest will be necessary upon the death of the spouse, since that spouse was a co-tenant. There is no survivor between the spouses at this time without that retitling. I've been on the unfortunate end of having to explain that there's no survivorship and that probate is necessary. And, it's unbelievable and really not unbelievable because people don't think about it, but most people think that remarriage just resurrects the tenancy by the entirety's form of ownership. So we've come to the end of the road today as far as my presentation is concerned. As you've heard, there's many things you need to keep in mind when dealing with spouses, entireties property, homestead property, non-homestead property, divorce, judgments, divorce documents, etc. And these are issues we are happy to help you with at Stewart Title. Here's the Florida Bar CLE accreditation information for anyone that may need that. And now I'd like to open this up to all of you so we can hear your stories for a few minutes. So if anyone is unmuted, unmute yourselves. If you want to get on camera, I'd love to hear what you have to say. Take it away.
Hi, thank you so much for the presentation today. We do have one of these situations that we're working through right now. Mo, if you want to share about that since this is your buyer.
Yep, I have a buyer named Valerie Manning. She asked us to basically she wants to make sure that her property after she passes away goes to her adult children, not to her second spouse. So we were working with you guys at Stewart Title to make sure that we can do that and adding the special language that she would like on the deed. And we're having her spouse sign the deed acknowledging that he will be giving up his homestead rights
Perfect.
um, in the case, or basically if she passes away.
Hmm. Perfect. And a
This
lot
is
of times
very
people don't
timely.
realize they need to go further.
Mhm.
So, yeah.
And we
So
had
good.
another fun one of basically back in the days, about a year ago, where we caught somebody who's married at the table and we had to stop the closing.
Hmm. I heard not too long ago about somebody who said, when they were asked, "Are you married?" and they said, "Well, it depends on where I'm located. Depends
But
where I am." And it's like, wait a minute, you're either married or you're not. It doesn't matter if you're in another country. If you're married in that country, you're married here. So,
We've had that, and we've had the, I'm spiritually married, but not legally married. I'm like,
yeah,
okay, tell me what spiritually
That's a good one.
married actually means.
exactly. Exactly. Let's get to the crux here of
That's
the matter.
funny.
Any other wild stories or anything of that nature before we wrap it up? Okay. Well, with that, if there's any questions on today's presentation, feel free to contact me. My contact information is on this next slide. And we thank you so very much for spending this time with us. We know your time is valuable. We thank you for being a valued agent. We know that you have choices, and we thank you for consistently choosing Stewart Title. So with that, have a wonderful rest of your day. And again, thank you.
Thank you, Caroline.
Thanks,
Thank you,
Caroline.
everyone.
Thank you so much.
Thank
Take
you.
care.
Thank you all.
Okay.
Bye.
Bye.
Bye, everyone. Thank you.